So let's talk a little bit more about this idea of precedent. This is what is called a common law system, and this is how the US judiciary operates. The idea is that higher level courts set legal precedents to which lower courts must adhere. If we did not exist under this system, what would happen is things would merely be decided on a case by case basis. One case that is decided in Texas might have a different outcome than a very similar case that is decided in Massachusetts. And as I noted to you in the lecture on civil rights, the entire idea of a just system is that you treat equal, or rather like cases alike. You treat like cases equally. And so what a common law system does is it ensures that the courts adhere to treating like situations alike. And so this is what is called stare decisis, translates into let the decision stand. And this establishes precedent. It's why whenever the Supreme Court makes a decision regarding a case, it changes the way courts operate for similar cases across the country. It establishes a uniformity of rules regarding how to treat certain situations. Lower courts cannot overturn precedent. They might try to, but the only way they can do that is to make an argument for why their particular situation, though it may seem similar to a previous decision, is somehow distinct. But that doesn't always fly. And when the Supreme Court has ruled on something, it's very difficult to rule in a way that counters a Supreme Court decision. The only thing in this country that can overturn a Supreme Court precedent is a future Supreme Court. And the reason why we have this system is largely because of our experience under the British. The British used a common law system, and we inherited that system in the United States. Other countries have what's called a civil law system, which basically means that precedent doesn't really hold firm, and cases are decided on literally on a case-by-case basis. Courts only pay attention to the facts of a particular case, and they don't really take into consideration previous court doctrine. In the Louisiana state courts, they still adhere to a civil law system primarily because of their experience under the French. And France, as well as many other countries, still have a civil law system. But nationwide, we have a common law system, and if, for example, a case were to make it out of Louisiana and into the federal courts, it would be subject to the common law nature of the courts, and Louisiana is still subject to the common law system and Supreme Court precedent. But within the states and others, for matters that are solely within interstate borders, there does exist a civil law system. So where do the courts get off? Where do they get their authority? Well, from several places, in fact. They derive their power directly from the Constitution, Article 3, Section 1. The judicial power is vested in a Supreme Court as well as other inferior courts ordained and established by Congress. And judges in these courts shall hold their offices during good behavior. So one thing that is important to understand is the Constitution only creates a Supreme Court, and it only mandates that court have a Chief Justice. The number of total justices on the Supreme Court is left to Congress to establish, and the organization of lower courts, aside from the Supreme Court, is also left to Congress. So that is why, throughout history, the Supreme Court has had, at various times, 5, 7, 6, and currently 9 Supreme Court justices. There was actually an effort during the Roosevelt administration to expand the size of the Supreme Court so that Roosevelt could put on the bench his own appointees in order to uphold the constitutionality of his New Deal programs. We'll get more into that later on, but this did not go well, and ultimately the court packing scheme failed. Supreme Court also gets its power from its own rulings. And Marbury v. Madison, this case marked for the first time that the Supreme Court struck down a federal law as unconstitutional. It was quite controversial at the time, the idea that an unelected Supreme Court could actually overturn a law that was passed by the elected representatives of the legislature, but it was determined in Marbury v. Madison that the Supreme Court ultimately decides what the law is. And if they find that Congress has passed a law that runs afoul of the Constitution, they have the power to deem it unenforceable. Now, though Marbury v. Madison is the first time that the Supreme Court declared a federal law unconstitutional, what is less discussed, yet ironically, is another case where the Supreme Court derives its power was Dred Scott v. Sandford. This is a case where a slave tried to sue for his own freedom, and the court ruled that Congress did not have the constitutional authority to ban slavery in the newly acquired territories. This was the second time, in 1857, that the Supreme Court declared a federal law unconstitutional. Now, there are a number of other cases where it was determined that federal law and the Constitution is ultimately the supreme law of the land, and that lower state laws, should they go against the national or constitutional law, that they would be rendered unenforceable. And that is in these three cases right here. These are three, not only these three, but these are three early cases that established this: Fletcher v. Peck, McCulloch v. Maryland, Gibbons v. Ogden, primarily with regard to Commerce Clause jurisprudence.